All right, everyone. Thanks for joining me today. J.R. Dukes here at your service. I have a specific piece of news that we're going to go over today. Normally, we're always talking about Fannie Willis, it seems like, but today we're going to talk about a decision directly from the U.S. Supreme Court. I want to take care of a few housekeeping matters real quick. Appreciate everybody coming on in and joining us. I want to make sure everything is working the way it should be working. Hello to everyone on YouTube. Okay, we're now on X. I see everybody starting to pile in, and it looks good. If y'all can hear me or you can't hear me, let me know for sure. Okay, Twitch just came online. Fantastic. Looking good always. Introduce yourself if you haven't done so already. Of course, I am J.R. Duke, your host. I felt like one of those old-timey Fantasy Island things. I'm Mr. Rourke, your host. Welcome. I don't know if y'all are old enough to, most of y'all are old enough to remember that, but that's what I always think of when I say something like that. All right, we have American Nana in the house. Thank you for being here today, American Nana from West Virginia. Zach, you always are so special, dude. Another super chat. I appreciate that. I really do. You've been spoiling me the last day or two. Every time I got something posted, you're helping the cause, and I want you to know I appreciate that. Jim, thanks for joining us. We are winning. Of course, we're winning. Make sure y'all introduce yourselves, say hello, let me know where you're from. And again, Jim, thanks for joining us. So we're going to start diving into it here pretty quickly. Again, Zach, I appreciate you, pal. Very kind of you to donate and help the channel out. I don't really have a lot of bills here. The only thing I really pay for is StreamYard and a few other little incidentals, but it is appreciated. Make no mistake about it. So, all righty. Let's start diving into it. Let's take a quick overview of what we're going to be taking a peek at today. Instead of talking about Fannie Willis, and by the way, just a quick note for tomorrow and or the next day, it looks like Megyn Kelly has done an interview with the great Ashley Merchant. Y'all know I just love her absolutely to death. I would take time and show the interview today, but I think I'm going to save it for tomorrow. Good interview. Just love seeing her in just about anything. She's just really, really a very zealous and good advocate for her client, Michael Roman, and he's lucky to have her as a defense attorney. And of course, she's been responding to this outrageous verdict that came down from the judge just this week, and we will talk more about that at a later time. We have to talk about today, the centerpiece here is this U.S. Supreme Court decision that, in my understanding of the law, I've never heard of it. Generally, there's always basically the feds that take care of immigration, and the states pretty well hands off. You can't go there. You can't touch anything to do with immigration or any type of federal matter. And generally, immigration is a federal situation. Now, it was a split decision. I went ahead and put pictures of all of the justices that you can see on your screen right there. And you will notice, by the way, if you have any questions, let me know. Let me go ahead and post this real quick too. If you would like to join the chat here today, just got to have a microphone and a camera so we can see you. And I will put the information in the chat so we can get that all out of the way. It's pretty easy. Okay, I'm going to give you the link right now. And there we go. All right, so if you'd like to join, just click that link. There's instructions and everything that's included in the course of this. Hey, Danny, thanks for joining us today. All right, dig. Okay, well, thanks for being here, Jim. Danny, thank you. American Nana, of course, and we've already said hello to Jim. Yeah, that was a great interview, I think, if you're talking about the one with Megyn Kelly and Ashley Merchant. But again, we'll talk about it, I promise. It's going to be a lot to talk about with Fannie Willis still to come. There's no way that saga is over by any stretch of imagination. All right, so over here in Texas, we generally have it to where the feds pretty well handle. If you have any questions, yeah, go ahead and put them in the comments below. I'm happy to help out with any questions that you might have. That's what I'm here for. I went ahead and I put the 9 justices that serve currently on the U.S. Supreme Court, and I put them in the order from the left, because they're on the left-hand side of things, and all the way over to the most conservative justice. So as far as my opinion is concerned, this is how this would look as far as the most conservative, I should say the most liberal on the left-hand side and the most conservative on the right-hand side. Now, the first lady here, this Jackson, what's her name? Jackson Brown. She is the newest justice on the U.S. Supreme Court. Yeah, her name is I can't ever say her name. Ketanji Brown Jackson. We'll just call her Brown Jackson. She, in my opinion, is probably the most liberal, but it would be a toss-up between her and the Sotomayor right here beside her. And then, of course, you have Kagan right here, Justice Kagan. Let me make sure I have her full name for y'all. Justice Kagan. She and these other two ladies are essentially the liberal wing of the U.S. Supreme Court. That's probably no surprise, thanks in large part to Donald Trump, who was able to appoint 3 or 4 of these justices. It is a court that enjoys a very heavy conservative swing, which is probably good news for most of us, depending on your politics. Now, I put Justice Roberts right here, position number 4. He is kind of one of those weird votes. Sometimes they put someone on the court. They believe that it's going to be a conservative individual. They believe that the individual has what they do is they go back and they look how they voted in the past. And they look at what rulings they've made in the past. And they have a pretty good idea how they're going to act once they get to the U.S. Supreme Court. But a lot of times, these individuals turn out to be what you call wolves in sheep's clothing. Is what happens because you put them up there and they don't vote anywhere near the way you expect them to vote. Now, that is rare, but it does happen. And I would say that most conservatives probably view John Roberts that way, the actual Chief Justice that was appointed, I believe, by George W. Bush. So he is conservative, but every once in a while he comes up with one of these rulings that's just really out of left field and is somewhat perplexing at times. He just doesn't always vote the way you think a conservative would vote. And then we have Kavanaugh, Amy Barrett, what's her name? Amy. She's got one of those hyphenated names. I have the names written here on my iPad for quick reference. May not always be as quick as I like it to be. Yeah, but it's Justice Amy Coney Barrett. And then, of course, we have Neil Gorsuch, and then this other two here. Of course, we all know at the end, we all know Clarence Thomas. He's probably one of the oldest, if not the oldest, on the court. And I believe he was appointed by George H.W. Bush a long time ago. And of course, he is surprisingly extremely conservative. I would say he's the most conservative member on the bench. And let's see, I want to make sure I get all these names right. We got Sotomayor, Clarence Thomas, John Roberts, Samuel Alito. Alito is the second to the end over here on the right-hand side. So we have Alito, Kagan, we got Amy Coney Barrett, Neil Gorsuch, and that's who he is here. This is Neil Gorsuch, if I'm saying his name right. Anyway, that's just the way I see the court. If you think it should be different, let me know. We can always move these pictures around. But you essentially have a supermajority of 6 votes. And today's vote, I believe, was 6-3. It was definitely the conservatives versus the liberals. I am actually pretty pleased with this vote. We all know what's going on the border. On the border, we effectively have a president who's in the middle of a power grab. And how does the power grab work? Well, they have open borders, and anybody that wants to come across the border can effectively come across the border. And the reason they're doing this is because the Democrats figure that all of the Latinas coming across the border are effectively, eventually going to be loyal, devoted Democrat votes. In addition to that, a lot of them might not be able to vote, obviously, because they are technically illegal aliens. And yes, I call illegal what it is, illegal. What I will tell you is that it does matter that there are so many illegals in this country as far as voting goes, because what happens is apparently they take a census vote a little more regularly than I thought they did. I thought it was every 10 years. But apparently when it comes to Congress, they do it like every 2 years, so they can make sure that that every state has the right amount of representation in Congress. And when they count individuals, they also count illegals. They count any person when they put those statistics together. So that's another interesting angle to this whole situation. But anyway, I want to get into this particular ruling and read through a little bit of it. I think it is an interesting read. So let me bounce out of this, and we're going to go into the video that I have. We'll start off with that. And let's take a look at the actual breaking news pertaining to this story. So let's hope everything works out the way it's supposed to. Here we go.
We are following some breaking news. The Supreme Court is allowing a controversial immigration enforcement law in Texas to take effect while a lower court reviews whether or not that law is legal. Under the measure, state law enforcement has the power to arrest people accused of crossing the southern border illegally. That typically is under federal jurisdiction. Federal jurisdiction meaning that it is up to federal agencies like the Border Patrol to patrol the border, to enforce immigration law, not up to states. Yesterday, we had announced that Supreme Court Justice Samuel Alito had extended an order that was barring Texas from detaining and jailing migrants. It seems that now, while the law is under review, it will be allowed the state of Texas to at least continue jailing some migrants. CBS News immigration and politics reporter Camilo Montoya Galvez has been following this, and he is on the phone with us now. So, Camilo, this decision is not final. Clearly, can you talk to us about what the ruling is, or where it stands at this point, and how it differs from the news that we gave yesterday, where Texas was being held from being able to continue to stop and jail migrants?
That's right, Lily. And the bottom line is that Texas state officials at the state and local level can now arrest, stop, and detain migrants who are suspected of crossing into the U.S. illegally from Mexico, and also allow state judges to issue de facto deportation orders against suspected violators of this law known as SB4 that the Biden administration, Lilia, has argued is unconstitutional and interferes with immigration enforcement, which, as you know, has for many years and decades, in fact, been a federal responsibility, something that is typically carried out by agencies like the Department of Homeland Security, not individual states. But right now, the Supreme Court is allowing Texas to enforce this law through this procedural order that, again, as you underscored, does not actually get into the merits of the law or its legality, but it allows the state nevertheless to implement it while an appeals court in New Orleans reviews the actual legality of it. It is important to note, Lilia, that a federal judge in Texas has already said that this law is unlawful, that it violates the Constitution, and that federal immigration enforcement would be hindered by this law because, again, arresting and deporting migrants, rather, are federal responsibilities. But that ruling by that judge in Texas has been stayed by the Fifth Circuit Court of Appeals. That is now the court that will review the legality. But again, until that ruling comes to fruition, the state can implement this.
Let's talk about the practice. Camilo, I am old enough to remember SB 1070, which was a law that back in the era of Sheriff Joe Arpaio was extremely controversial in Arizona. And it was already decided in the year 2012 that you cannot pass laws like these. You cannot have law enforcement stop migrants without engaging in racial profiling, which is what made it back then unconstitutional. What are the concerns right now? Is this a similar debate, for people who are wondering, okay, so why is it up to the federal government and why not up to state authorities, given that there is a crisis at the border? Why not have the state police or local police agencies engage in this? Talk to us about what the pushback is against this law.
Well, Lilia, critics of the law have certainly said that it would lead to racial profiling because they believe law enforcement officials at the local and state levels will not be able to adequately and properly determine whether someone is a migrant or not, or whether someone crossed into the U.S. illegally. They believe that that probable cause is too vague and can lead to U.S. citizens or permanent legal residents or other immigrants who are here lawfully to be caught up in this enforcement of this law. But Texas has argued that this is in some ways a narrow law because they are going to go after people who agents see crossing the border illegally, or migrants who are found in cars where smugglers are trying to smuggle people into the country. So Texas has argued that this is needed to deter illegal immigration and to discourage people from crossing the border illegally, but obviously critics say it will lead to racial profiling. Critics also say, Lilia, that this will divert key and limited public safety resources away from more serious crimes, and that it will prevent county and state officials from focusing on those more serious criminal efforts like human trafficking, murders, and other more serious crimes.
Yeah, but what you have to remember is the state of Texas is literally being overran with all these illegals. They get a small taste of it in New York and Chicago and some of these so-called sanctuary cities, but they have no idea what Texas and some of these other border states like Arizona and maybe a little bit of New Mexico go through. I know Arizona has a serious problem, but Texas gets the brunt of it just because they have such a long border with Mexico. And I don't blame Texas. I would definitely be staffing up. They may have some criticism about this particular bill being implemented, but I can tell you friends that I have in Texas are applauding this particular bill being allowed to stand. Now, I want to be clear. This is not a basically what we could call a traditional ruling in the sense that Texas can indefinitely continue with this law, if you will. However, it is a good first step because what has happened is effectively they passed this law, and I believe the law was stopped by a judge, and then it was appealed to the Court of Appeals, and I believe they stopped. I think the first judge allowed it. The Court of Appeals blocked it. They appealed to the United States Supreme Court, and I think it was Alito who said he reversed the decision and said, no, the law can be enacted as of right now. They extended that permission this past Monday. And then today, the full court came out with this decision. And the effective impact is this, my friends. It allows the decision to essentially go back to one of the lower courts for litigation, for them to work out whether or not this is constitutional, whether or not this is legal. However, it still is very good news for Texas because for now, we get to see how well this bill will work out, if it works out at all. I'm sure that it's going to have a lot of positive implications for the people in Texas, and I'm sure it's going to stop, if not curtail, the amount of illegal immigrants coming across the border. It's kind of just common sense. But what is so amazing about this particular ruling, in my opinion, is two things. It forecasts what the Supreme Court is likely to do when this case reaches them in its entirety. And the second provision here is, as I said earlier, this is the first time, at least in my mind, that the United States Supreme Court has ever made a ruling like this. Traditionally, anything to do with immigrants has always been in the hands of the federal government, period. And that's the reason why the Biden administration is doing what they're doing, which is nothing. They want all of this immigration coming in. They want all of this illegal immigration. And I will say one other thing about this. As a side note, you heard me say it before, and I'll say it again. I don't necessarily believe that all of the Latino people coming across the border are going to be necessarily dependable votes for the future of the Democratic Party. And the reason for that is I know personally a lot of Venezuelans, a lot of Cubans, a lot of Colombians for that matter, they despise socialism. They have had a taste of that Kool-Aid and they don't like it. They don't want it. So I think Joe Biden and his friends might have actually got into something that they might regret one day, but we'll just have to see if that pans out. Let's take a quick peek at this next article that I want to share with you. And essentially what this is going to be is a look at to exactly what is this Texas immigration law. They call it SB Senate Bill 4 out of the state of Texas. And we're just going to read parts of this here. The U.S. Supreme Court on Tuesday allowed Texas to enforce its illegal entry law amid an ongoing lawsuit. It's important in my mind to know exactly what this is going to cover and not cover. Texas lawmakers in 2023 approved Senate Bill 4, of course they call it SB4, which seeks to allow Texas police to arrest people for illegally crossing the Mexican border. It was expected to go into effect in early March, but faces legal challenges from the U.S. Justice Department, aka the Biden administration, and immigration advocacy organization. After previously blocking the law from going into effect, the U.S. Supreme Court allowed the state of Texas to enforce the law as court challenges remain. So that's what we just kind of went over. So let's briefly talk about, let me see if I can blow this up for you a little bit. Let's briefly talk about what is Senate Bill 4. This new law would make it a state crime to cross the Texas-Mexico border between the ports of entry. If a police officer has probable cause, so that's the standard, probable cause to believe a person illegally crossed the Rio Grande, that person could be charged with a Class B misdemeanor. So the first encounter with police would only be a misdemeanor, specifically a Class B misdemeanor, which carries a punishment of up to 6 months in jail. For subsequent offenses, however, the person could be charged with a second-degree felony. So it is a drastic increase in penalty if you agree to go back across the border and you are caught crossing back into the states illegally. That's the key. You could face up to 20 years in prison. If the migrant is convicted and has served their sentence, a judge would be required to order police to transport them to a port of entry. A judge could drop the charges if a migrant agrees to return to Mexico. And police could turn over migrant families to Border Patrol agents to avoid separating children from their parents instead of arresting them. Is the law being enforced? The U.S. Supreme Court on March 19th, today, issued an order allowing the state of Texas to enforce SB4 as challenges against the law proceed in federal court. Just one day before, the High Court had extended a temporary court order blocking the law from going into effect until the justices decide whether Texas could enforce the law amid an ongoing lawsuit. Remember, this is still being litigated in these lower courts. The lawsuit was brought forward by an immigrant rights advocates and the federal government, aka the Joe Biden administration. Could any undocumented migrant be arrested? The bill allows police to question and arrest anyone they believe entered Texas through Mexico illegally and is currently without legal immigration status. However, the author of this law says it is meant to target people who recently crossed the border, not undocumented immigrants who have been living in Texas for years. However, if I was living in Texas illegally for years, I would be concerned, and all due fairness, this would be very concerning to me. Texas statute of limitations blocks legal proceedings for misdemeanors 2 years after an offense has occurred. So what they're saying is if you enter the country like 3, 4, 5 years ago, this law would not apply to you because your alleged crime of crossing the border illegally would frankly be too old. The statute of limitations would bar any type of criminal prosecution under this particular statute. The statute of limitations is 3 years for many felonies. SB4 prohibits police from arresting migrants in public or private schools, churches, and other places of worship, healthcare facilities that provide forensic medical examinations to sexual assault survivors. The bill doesn't prohibit arrest on college or university campuses. So they wouldn't be able to go into your school. They wouldn't be able to show up at your church. For example, if it was a Latino church of some sort, the police couldn't just show up there and start checking IDs, all right? Why is the law being challenged? Immigration advocacy organizations and the Department of Justice say the law encroaches on the federal government's sole authority over immigration. Of course, we just talked about this, and will lead to racial profiling by the police. Texas officials have agreed the state needs to step in because the federal government isn't doing enough to stop illegal immigration. That's the understatement of the year, right? Can Texas enforce immigration laws? Federal courts, including the U.S. Supreme Court, have previously ruled that immigration laws can only be enforced by the federal government. Texas has argued the law follows federal immigration laws, and the state has a right to defend itself under Article 1, Section 10 of the U.S. Constitution, which prohibits states from engaging in war on their own unless actually invaded. A federal judge who blocked the law in February says he didn't see any evidence of a war in Texas, and that the federal government would suffer irreparable harm, end quote, under the law because it could inspire other states to pass their own immigration laws. Yeah, you think? You can bet other states are going to pass similar laws. If they allow Texas to do it, they're going to have to allow the other states to do it. That's pretty clear. How could this affect asylum seekers? Anyone who enters the U.S. legally or illegally has up to 1 year to request asylum. The federal government is asking migrants not to show up at a port of entry and instead make an appointment to meet with an immigration officer. That's in the case you want to seek asylum. But available appointments fill quickly, and many migrants opt to cross the border anyways from ports of entry and surrender to U.S. authorities. Under SB4, if Texas police arrest a migrant before they surrender to the Border Patrol, immigrants who apply for asylum and are researched by federal agents for criminal histories could be subject to removal from the United States if charged with the new state crime. That's kind of always been the way, though, folks. If you were here legally, or I should say, well, legally or illegally for that matter, even with asylum, if you commit certain types of crimes, you're eligible to be deported under current immigration law. All right, where can I find more information? Well, you can Google it. I'll just fix that up for you. All right, so that's that as far as what is SB, the Senate bill out of Texas. We now know what that law is. SB4 is what they call it. All right, so let's turn to questions before we start drilling into the document. Alrighty, like I said, any questions, feel free to put them in the comments here and we'll go through them. Appreciate everyone taking time to comment. Zach, definitely appreciate your comments. All right. Yeah, I don't know any other country that allows illegals to just simply invade at the border without repercussions. It is really, really striking, and frankly, it's a shame. A country without borders is not a country. I mean, I think it's just that simple. Do y'all remember back in the 1980s where they conned Ronald Reagan into essentially giving everybody that was here illegally amnesty, and in return the Democrats promised at a later date, but very soon, that they would secure the border, they would seal the border, and we would never have this problem again. And of course the Democrats lied. It was a big sham. Ronald Reagan got screwed in that ordeal, to put it bluntly. I remember it clearly. And of course, what are we looking at now? 40 years later, 10, 20, 30 some years later, we're looking at the same thing again. It's just a, well, what was AC 90, well, yeah, we're almost 40 years into it now. It's, yeah, we're back where we started from. Ronald Reagan was conned, and I hope that we don't get conned again on the situation. They're going to have to apparently come up with some type of amnesty situation at some point in the future. I don't see any other way about it, unfortunately. However, before they allow something like this, or a pathway to citizenship is what they generally and normally say about these type of situations, they have to seal the border and enforce border crossing. It's really just that simple. All right, Zach, note the language used, immigrants who are here lawfully versus, yeah, they love to play with, they call them newcomers now, by the way. My son-in-law just got back. It's criminal. Yeah, it is criminal what's going on, what's going through. Yep. He's Army and goes back next week. Well, we hope your son is well and he stays safe, Jim. Thanks for his service. And of course, I'll add him to my personal prayer list, as I do all of our individuals and men and women serving in the armed forces. We salute each and every one of them. All right. Kurt, thanks for being here today. Happy on this. Yeah, everything is going good. Appreciate it. Thanks, Jim. Yeah, first offense is a misdemeanor, Zach. Is not much. Well, I don't think it, frankly, would have passed if they would have said first offense would have been some type of felony. You know, a felony really is going to mess up your life. So it's like, I don't think they could have probably passed something like that in the state of Texas. So, and remember, it's not a class, it's a class B misdemeanor. It's not the easiest type of misdemeanor, whatever their lowest misdemeanor is there. So it's moving up towards the A misdemeanor. It is a class B, which will give you I think a class A is up to 1 year in prison. And that's generally the difference in a misdemeanor and a felony in most jurisdictions that I know of. April, thanks for joining us today. Yeah, see Zach, and okay, well, there's commenting there to you. Jim, thank you. Thank you all. I appreciate that. Okay, let's take a quick peek at this document right here. Now, some of these documents, frankly, can be boring, but a lot of these documents, something in here, to be perfectly honest with you, I find very interesting because it gives you an idea of exactly how are the justices thinking What is their rationale when they decide these type of cases? And this is not a very particular long document. It does have the main decision at first, and then at the rear of the decisions, I think we have two what we call dissenting opinions. Two of the liberal justices, I believe, signed one of the dissents, and then one of the last, I think it was the Jackson lady, I think she filed her own dissent because she had a different type of dissent. So let's go ahead and just take a quick peek at this. Supreme Court of the United States, we still have plenty of time left. Yeah, we got at least 30 minutes, so we're good. Supreme Court of the United States versus Texas. That was the title of this case. So I got this right off of the United States Supreme Court's website. So here we go. And it starts off the applicants to vacate stay presented to Justice Alito. So it was Justice Alito that they came to him and they said, hey, we would like you to reverse this decision from the lower court and allow this Texas law to go forward. And that's what he did. Justice Alito are vacated. Justice Barrett, with whom Justice Kavanaugh joins, concurring in denial of applicants to vacate stay. If the Fifth Circuit had issued a stay pending appeal, this court would apply the four-factor test set forth in Holder, including, as relevant in this court, an assessment of scent-worthiness. This is a bunch of legal mumble-jumbo to decide whether to vacate it or not. So they're talking about how they arrive at their decision. Barrett, concurring in denial of application for injunctive relief. When they're talking about injunction, they're generally trying to stop something or prevent something from going forward, and that's what they were trying to do in this case. But the Fifth Circuit has not entered a stay pending appeal. Instead, in an exercise of its docket management authority, it issued a temporary administrative stay and deferred the stay motion to a merits panel, which is considering it in conjunction with the text challenge to the district court's injunction. Basically, that's when they originally stopped, and they put it here, SB4, that we just got done talking about. Thus, the Fifth Circuit has not rendered a decision on whether a stay pending appeal is warranted. That puts this case in a very unusual procedure posture. Yeah, that's putting it mildly. Administrative stays do not typically reflect the court's consideration of the merits of the stay application. Rather, they, quote, freeze legal proceedings until the court can rule on the party's request for expedited relief, end quote. Power and procedure. Okay, we're not going to get into that. Okay, deciding whether to grant a stay pending appeal requires consideration of the four factors, which are included an assessment of the applicant's likelihood of success on the merits. In other words, one of the things they consider is, at the end of the day, what is the likelihood that one party is going to be successful? That is not always easy to evaluate in haste, and an administrative stay buys the court time to deliberate. And they give some case law on this here. And they say this court stayed the issuance of a lower court's mandate because the filings regarding the application for stay in this matter were not completed until earlier today, and the justices need time to review these filings. At the same time, we stress that the administrative stay reflected no view of the underlying merits. Okay, so they're going through the case law on this here. We're not going to dive too deep into that because that really gets in the weeds. I want to mainly touch on the big, thick plot points here. So while we have not explained, by the way, these footnotes are generally interesting sometimes, and oftentimes they contain very important points that you need to understand. While we have not explained the source of the federal court's authority to enter an administrative stay, commenters have pointed to a court's inherent authority to manage its docket, as well as all writs, act, and they give the USC code right here. So, okay, we're going to move on. All right. It goes on that such stays are administrative does not mean they are value neutral. Their point is to minimize harm while an appellate court deliberates. So the choice to issue an administrative stay reflects the first blush judgment about the relative consequences of staying the lower court's judgment versus allowing it to go into effect. All right, and they're giving different cases here. Again, we're not going to get into that. I just want to touch the main points here so we don't bore anybody to tears. It goes on, minimizing the harm. That is another point that they use to evaluate whether or not to grant an injunction. It is not necessarily the exclusive justification for an administrative stay, because an administrative stay precedes a ruling on a stay pending appeal. The factors are obvious on the court's radar, and unsurprisingly, they can influence this stopgap decision, even if they do not control it. All right, so they give more case law about this here. So it goes on. So far as I know, this court has never reviewed the decision of a court of appeals to enter or not enter an administrative stay. So even they're acknowledging how unprecedented this particular action today by the United States Supreme Court is. And that's one of the reasons I wanted to talk about this, because it is just that. We use that word a lot, unprecedented. You know, we say that about anything and everything. But the reality is this is unprecedented, and the justices even acknowledge that. I would not get into the business. When entered, an administrative stay is supposed to be short-lived, a short-lived prelude to the main event, a ruling on the motion for a stay pending appeal. It's just a stopgap measure is what they're saying. I think it's unwise to invite emergency litigation in this court about whether a court of appeals abuses discretion at this preliminary step. So we are going to skip on down to where they're going to the next point. Okay. It goes, this time, it says, this time may come in this case or another when this court is forced to conclude that administrative stay has effectively become a stay pending appeal and review it accordingly. Again, they're just talking about, is it okay to go forward with this decision, considering that it's highly unusual and not really improper, but it's just highly unusual right here. So they went ahead, and you have a dissenting opinion here from Sotomayor, and this is kind of just touching the base of what she said. Justice Sotomayor, with whom Justice Jackson joined, so you did have two liberals that joined on this thing here, says, today the court invites further chaos and crisis in immigration enforcement. Texas passed a law that directly regulates the entry and removal of non-citizens and explicitly instructs its state courts to disregard any ongoing federal immigration proceeding. That's kind of remarkable when you think about it. That law upends the federal-state balance of power that has existed for over a century, in which the national government has had exclusive authority over entry and removal of non-citizens. The district court here declared that Texas's law amounts to nullification of federal law and authority, a notion that is antithetical, one of the big words for us here, to the Constitution, and has been unequivocally rejected by the federal courts since the Civil War. I told you earlier, this is extraordinary. This is unprecedented. I was shocked when this came down. I'm happy, but I'm shocked. It's going to be interesting to see how this finally plays out. Texas appealed that ruling and sought to begin enforcing its law while it appeals. With no seasoned analysis, the Court of Appeals issued an administrative order allowing it to do so. Texas can now immediately enforce its own law, imposing criminal liability on thousands of non-citizens and requiring their removal to Mexico. This law will disrupt sensitive foreign relations, frustrate the protection of individuals fleeing persecution, hamper active federal enforcement efforts, undermine federal agencies' ability to detect and monitor immediate security threats, and to deter non-citizens from reporting abuse or trafficking. It's just the end of the world, according to this justice, right? The court gives a green light to a law that will upend the longstanding federal-state balance of power and sow chaos. When the only court to consider the law concluded that it is likely unconstitutional. So she's saying, hey, look, this law is likely unconstitutional. We should not do what we're doing today, which is allowing this Texas law to be enforced. She says that it's likely unconstitutional. This law implicates serious issues that are subject to ongoing political debate, and Texas's novel scheme requires careful and reasoned consideration in the courts to determine which provisions may be unconstitutional. Although the court today expresses no view on whether Texas law is constitutional, that's the reason why it was pretty crisp and dry above. They were just going into the facts as to why they were doing what they were doing, and although it's essentially unprecedented, it's not improper, and that was pretty well where they left it at, and she's making note of it here. It expresses no view on whether Texas law is constitutional, and instead defers to the lower court's management of its docket. Well, that's what they always do. when it's essentially like reversed and remanded, what they call it, it always goes back to a lower court because they want the work of the case, so to speak, to be done by the lower courts. That way, when it eventually works its way up to the U.S. Supreme Court, they have a full range of things to look at because it's been looked at by many people and many courts by the time it generally, customarily, and normally makes it up to the U.S. Supreme Court. The Court of Appeals abused its discretion by entering an unreasoned and indefinite administrative stay that altered the status quo. This court stands idle because I dissent. So that's pretty strong language from her. I like the way she said it. This court stands idle because I cannot, and I dissent. So that's what she was complaining about. And she gives some case law about it right here. And this is her dissent. She's just complaining a little bit more about it. All right. She says also this is Sotomayor dissenting on this particular portion, just to let everybody know where we're at. The Texas Senate Bill 4 permits the state to arrest or remove to Mexico non-citizens who attempt to enter or reside in Texas while instructing state courts to disregard any ongoing federal immigration proceedings. Again, unprecedented. It's something that I have never seen. And she's citing a bunch of case law right here. It also makes it a crime for a non-citizen to attempt, enter, or be found in Texas after previously having been denied admission to or excluded, deported, or removed from the United States, or having departed the United States while an order of removal was outstanding. She continues, the crimes are punishable with thousands of dollars in fines and up to a year in prison. Once Texas charges a non-citizen under SB4, the state judge may, with the consent of the non-citizen, enter an order that requires the person to return to the foreign nation from which the person entered or attempted to enter before any conviction. And she goes on to cite the section here. Once a non-citizen is convicted under SB4, however, the judge shall enter, she's using the language of the law, and quote, an order requiring the person to return to the foreign nation from which the person entered or attempted to enter, end quote, and after he complies with his state prison sentence, okay? Failing to comply with the state removal orders is a second-degree felony, punishable by up to 20 years in prison. So the second time around, it becomes much more serious, up to 20 years in prison. And she cites the section there. Strikingly, state judges must explicitly disregard any parallel federal immigration proceeding. And she cites the section there. A court may not abate the prosecution of so-and-so, this SB4, on the basis that a federal determination regarding the immigration status of the defendant is pending or will be initiated. Again, she's just complaining about the whole thing. She goes, the United States, 2 private organizations, and the county of El Paso has challenged SB4. It is a thorough 114-page opinion, and the district court granted a preliminary injunction. So she's going through the weeds on this again. I'm not going to rehash all of that. She does say that procedure can be just as consequential as substance. The district court concluded that SB4 was likely unconstitutional and would cause immediate chaos were it to go into effect. Texas nonetheless asked for permission to enforce the law while appealing the preliminary injunction. Without any reasoned analysis, the Fifth Circuit Court granted relief in a one-line administrative order. The Fifth Circuit Court abused its discretion, and this court makes the same mistake by permitting a temporary administrative stay to alter the status quo that has existed for over a century. She's talking about the balance between the federal and state government. When a court concludes that a law or likely is unconstitutional, the decision generally takes immediate effect absence of stay. A stay supersedes or suspends rather judicial alteration of the status quo. And she gives the case law for this right here. She's basically saying, I don't agree with anything you people have said here today. I'm not happy about this whole thing. This is where the administrative stay comes in. An administrative stay or a temporary stay is even more preliminary. It is intended to pause the action on the ground for a short period of time until the court can consider a motion for a stay pending appeal. For the same reason, at a minimum, administrative relief should, number one, maintain the status quo, and number two, be time limited. The Fifth Circuit's administrative stay here was neither, and thus constituted an abuse of discretion. That's one of them lines they always use in legal proceedings. It's an abuse of discretion. Okay. Here, the Fifth Circuit administratively stays upended the status quo because it allows SB4, a brand new state law that alters the delicate balance of federal and state power in immigration enforcement to go into effect. The court preliminary enjoins SB4 and declined to stay that injunction. The Fifth Circuit did not need to enter an administrative stay to preserve the status quo. The district court's decision already achieved that. The Fifth Circuit abused its discretion in entering the status-altering administrative stay. You know what I picture in my mind as she's going through this? She's kind of like laying on the ground, and she's, kind of like a baby does. You know how a baby takes they lay on the ground, they put their hands out, and they, that's exactly what's going on right here. In summary, District Court concluded that SB4 was both likely unconstitutional and would cause immediate turmoil, and denied Texas's request for permission to enforce the law, nonetheless, while appealing the preliminary injunction. Without any reason analysis, the Fifth Circuit granted that relief, and this court now permits the Fifth Circuit's temporary administrative order to linger indefinitely. Cue that song that says you have to let it linger. Remember that one? I'm sorry. All right. The real world consequences of SB4 may be, many of which the district court recognized, and she cites it here, illustrate why the Fifth Circuit and this court should have proceeded carefully and deliberately to maintain the status quo. I think you get the gist of Sotomayor. She's not happy with this particular ruling, and she's the one that dissented on her own on this particular deal here. I think right here too, the court confronts a state immigration law that will transform the balance of power at the border and have life-altering consequences for non-citizens in Texas. Texas novel scheme, she calls it a scheme. That's not a good word if you are for something. Texas novel scheme requires careful and reasoned consideration in the courts. The district court gave SB4 careful consideration and found that it was likely unconstitutional. How many times you got to say that same sentence, right? The Fifth Circuit Court has not yet weighed in, but nevertheless issued a one-sentence administrative order that is maximally disruptive to foreign relations, national security, the federal-state balance of power, and the lives of non-citizens. The court should not permit this state of affairs. I dissent. So that's the third justice saying, the hell with this. I'm not a happy camper. All right, and here's Justice Kagan. She's got the complaint. You ready? Okay, here's her complaint. Justice Kagan, dissenting from the denial of applications to vacate stay. I respectfully dissent from the court's denial of this application to vacate the stay. In my judgment, the applicants justify the four-factor test set out in Holder. My views of the merits are, as always, in this posture preliminary, but the subject of the immigration generally and the entry and removal of the non-citizens particularly are matters long thought the special providence of the federal government. Again, we're going state versus government. That's the theme here, which has been the law of the land for a long time. In all fairness, they are correct in their observation. Given that established understanding, I would not allow Texas Senate Bill 4 to go into effect. And in the circumstances, I do not think the Fifth Circuit's use of the administrative stay rather than a stay pending appeal should matter. Administrative stays surely have their uses, but a court's unreasoned decision to impose one for more than a month rather than answering the stay pending appeal issue before it should not spell the difference between respecting and revoking long settled immigration law, as I just said. So her dissent was a little bit more short and sweet to the point. So I think you get the idea on this here. Immigration is and has been a huge theme in this election and will likely continue to be a heavy theme in this election. Generally speaking, so far, immigration has been the number one issue, followed by the economy. And every once in a while, they change places where the economy is the number one concern of voters. But in this election cycle, it seems to be changing. So it is a top concern and a serious concern. And both of the candidates are going to be talking a lot about this decision. And it's going to be interesting in my mind. Where does the state of Texas go with this? How is this going to work? This will be a good test to see if the states can handle their own immigration policies, their own immigration as far as illegal immigrants coming in, if they can do a better job than the federal government. Are they going to be fair? Are they going to uphold our constitutional values at the same time as protecting our borders? That is what's going to be determined. Generally speaking, I applaud this decision. It's about time that we go ahead and try something different. And a place like Texas, I grew up in Texas as a teenager. I can tell you, Texas is a place that they are very proud to be Texan. Make no mistake about it. And they definitely are not happy about this invasion as they see it. And I don't know what else you would call it. When you have millions of people coming across your border and you got your federal government saying, we're in charge, but we're not doing nothing about it. Well, I can see that being a problem. I can see that making people mad and getting them unsettled. So that I'm sure y'all probably see it the same way. Let me check the comments real quick and make sure I haven't missed anything here. Yeah, I think, okay, I've got just a couple more. April, thanks for joining us today. Unless they really make it stick. Okay, great point. Yeah, we got some of these here. In Harris, they probably won't take the violations seriously. And then Jim ended. Okay, well, that's, I think that pretty well sums it up as far as this goes. I hope you all learned something about this. I appreciate you going through this with me. I think it's important to talk about these type of events. I'm still following that Fannie Willis case, the Jack Smith case, this bogus New York case, and of course, sweet Letitia James with sweet Fannie Willis. I'm all over it like a bad rash. I can assure you we're going to investigate every single end of it. So Lord willing, I'll be back with y'all tomorrow, and we will tune in for another exciting episode of what are we going to talk about today. All joking aside, I do appreciate each and every one of you joining me today, and thank you so much. Last shout out for my buddy Zach. I really appreciate the super chat. Once again, you are the man, and I appreciate you. Folks, I always say keep that mind free, never give up. And until next time, I am J.R. Dukes.